Okay, now, today we have a new member, Trevor.
Hi everyone.
Okay, so we are going to go through topic 2, larceny, today. So we will first, of course, everything have to start with elements, so we're going to state the elements.
So one thing before, we
Yeah.
don't have statute
Yeah.
for larceny.
Correct.
So we're not going to rely on statute like self-defense, then go to common law. We all directly go to common law, and we divide it to 7 elements. You can do as you wish, but this is how we did it, and Trev is going to start to say it.
And we make it
First
short
one
and
is-
effective, just
Yeah.
keywords.
Keywords.
Effective, yeah. So thank you. So the elements of larceny, as defined in common law under
Illich,
Illich
number 1.
by Wilson and Dawson. The actus reus, number 1, property capable of being
Stolen.
Property belonging to another, taken and carried away
Yes.
without the consent of the owner.
Perfect. And other 3?
So the mens rea, dishonesty, intention to permanently deprive
Yes.
without a honest belief of claim of right.
That's all we need, right? Every time there is an assignment about larceny, just 7 things. This is how I would do it. This is how I would memorize it. Capable, belong, carried away, consent, permanently, claim of right, fraudulently. Now we go to say which case is the authority and what to remember from it. So first one, property capable of being stolen. You remember with the name of Illich. I remember with the name of,
Not Illich,
not with the, which one?
Daily.
Daily. And I memorize it with 3 things. Check,
Yeah.
corp, and drug.
Yes.
So which one would you like to explain? Short and effective facts of the case.
I'll talk about the drugs,
Please.
which are the case of Anich, where the woman was in the house, 2 men broke in, it was the wrong house, they were looking for drugs, and it was the case of, now I'm getting confused. So
They were saying that the drug was someone else.
the drugs were somewhere else, but they were illegal drugs, illegal property, but they were still capable of being stolen.
Because
2 things to remember.
Yes,
it is physical
it's physical, yes,
item, yeah,
Yeah.
and it has,
Monetary
it
value.
has value.
yeah.
Yes.
So they're the two elements.
So
Yeah.
2 things to remember to use, otherwise one is a physical item and it has a monetary value. Yeah, and being illegal is irrelevant for this matter.
Yes.
So that's why one of the things we can use is this way. Second one is the corp. Would you explain
The
that?
corpse.
Corpse.
Yes. So the case of the corpse was Kelly, where Mr. Kelly and an accomplice took body parts, and they were charged with stealing the body parts from the hospital
College.
or the
Yeah.
college
Yeah.
that they were being used for.
Yeah.
They said they have no value, they're corpse, but the judge ruled that because they had been
Preserved.
preserved and modified,
Yeah.
they actually had a physical value.
Yes.
So they're actually property capable of being stolen for that reason.
Yes, physical has a monetary value.
Yeah, those 2 items.
Yes, and also in that case, judge says no longer is that divine kind of spirit and things. This has changed. This has been processed. This has
Yes.
been preserved, revised, or whatever wording they use. So no longer is that humanistic soul things.
And the
Yes.
body was given to the college for further examination or whatever. So the property literally belongs to the college. So if anyone take and carry away any parts of it, they actually take it without consent, isn't it?
So conclusion, 2 things. Is physical, capable of, has a monetary value.
And it belongs to other.
and belong to another.
Belongs to someone else.
And the third, we already said the drug corp and check.
The check.
Check.
Daily.
Yes. Would you explain that?
Yeah, so very simple.
Let's exhaust you while you're here.
I can't remember that one.
He just simply argued with saying that it's just a piece of paper.
Yes,
The
physical check, money
Yeah,
check,
it's just
bank check.
It's just a piece of paper. I cannot steal. There is nothing for me to steal.
Mm.
But the court held, well, it's a check. Check, you can exchange it to money. That check have a monetary value, and it's a physical item that you can take it away. Therefore, it is a property capable of being stolen. Last.
Yeah.
So whenever you use this, mention one of the nicknames or one of the names. So corp, drug, or check, or their precise name. Second element is
One more case for belong to other. Proton.
we haven't gone that. Second element is belong to another person.
That's what we have to do.
Yes. So second element belong to another person. So which the authority said, which authority for that case, I remember it with joint bank account.
Yeah.
Which means authority is you cannot steal your own money.
That's
So
right,
would you
yeah.
explain that?
So the case was a husband and wife, or de facto, that had split, and the wife accused the husband of stealing her money. The judge ruled that it was the money belonged to both of them. In fact, they owned 100% of the money each. So he could not, because he had a right to the property, he could not steal it.
Yes.
You
The
can't steal
property-
your own thing.
You can't steal your own property.
Yes. The correct property language is?
Oh, in terms of real estate, it was
Yes.
a tenants in common where you actually own 100% of the property.
So each party had an agreement, legal agreement, that each one own 100% of it. They can take as much as they want without other person's consent. So third element, which is carried away, taken carried away, I remember it with nickname case, 3 nicknames. One is van case, one is target case, one is price tag case. Van case, which is correct name is,
Wallace v. Lane.
would you tell us short and effective essential facts of the case?
Thank you. So where the van driver took some toe clips, which were the cyclist toe clips, and hid them in the front of the truck. So he took them out of the back of the truck and hid them in the front of the truck. He argued that he hadn't stolen them because he hadn't moved them out of the truck, and the judge declared that he had stolen them because they were asported. So it was asportation. So it was, even though it was a small amount of movement,
Yes.
it was still movement. So the items were physically moved.
No matter how short,
No matter how
physically
short.
is being
Correct.
moved. This is the important part of this case.
Yeah.
Second case, I remember the target, that the person takes the item in a change room, wears it, and then attempt to leave the Target or Kmart. I remember the Target case. So then somehow she stopped, and
This
she's
is
been
really
charged
bad.
with larceny, which the short and effective, I said the short and effective
Short and
fact.
effective. Well,
But you were saying
the-
in more sophisticated
So they were.
language.
So the woman had picked up an item off the rack, had hid it in her clothing, and was moving towards the exit when she was stopped. And her argument was that she had not left the store yet, so she couldn't be charged with larceny. However, it was declared that she had gone outside the bounds of the license given to her by the store. The license for handling the clothing is that you can take them off the rack, move them to the change room, and then to the checkout. That's the license that you have for handling the goods, not to take them, hide them, and go directly to the exit. So she violated the terms of that license.
And the third one is the price tag, which I think it was a lady.
Sean Morris.
Morris. It
His
was
guy.
Morris. Yeah, a guy, he played with the price tag, put the cheaper price tag into item which it was originally expensive to pay lesser amount.
Yes.
The judge would more affect.
And that was appropriation.
Yeah, because he didn't actually move any item from the rack. The
Mm.
item's still on the rack, so he didn't physically move them.
Mm.
However, he physically interfered.
Yes, adversely interfered with the goods. Yes.
Therefore, it's sit under appropriation.
Mm.
That's why there's a distinction between exportation and appropriation.
And the fourth one is without consent, which the leading authority is Illich. What's the
Illich is
nickname? Oh, Illich encompasses all of it.
Yes.
Wow, that's why.
Illich defined the elements of larceny.
What are the facts of the Illich?
Illich, actually later on in larceny by mistake, we'll talk about Illich as well.
Okay, can we say name?
Well, yes. So Illich is a person that he worked in a vet.
Oh, that's one.
Yeah.
Yes.
Vet clinic.
Yeah.
Yes.
And then the owner was away and asked him to do what he needs to do. But then when the owner came back, he was very unhappy with what he has done. And he prepared the money and says, leave, literally. Just go, take this and go. And then, okay, he took it and go. But then when he went home, he realized there were actually more envelopes there and there were extra money in it. So he just only kept it in his house. He didn't use it or anything. But the owner went to the police and says, he stole my money. And the police went to his apartment and says, do you have any extra money in the house? And he denies it. But then, of course, the police found him. And
But he had the money,
he didn't use it at all. He just
but
placed
he
it
had it with consent. That's how judge defines the consent.
as it was a mistake from the person that
It's
gave it.
from the giver.
Yes.
Yes, so, but this is important because it defines the definition of consent.
It defined what is larceny.
General, all
All of these
seven.
elements
So
are
by-
all defined
By
in
referring to one case, we
Yes.
don't need to say all these freaking cases. Is that correct?
No, because you have to
We,
still talk about all these cases because
we
each
do need
element.
to talk about the others as well.
I
That
see.
Because-
covers some.
Yeah, the cases is actually define each category
Oh,
of the
I see,
elements.
I see, I see.
Yes.
Okay.
Yeah.
Other three, which is mental elements of the things. One, your favorite claim of right. I remember that one with barrels, oil
The
barrels,
oil barrels.
and
Yes.
the Hungry Jack.
Hungry Jacks.
That's my nickname. And the lecturers are okay with marking. So what
Yeah.
are the correct name and what are the short and effective facts would you say?
So the oil barrels, you'll have to help prompt me with that.
Lopata?
Lopata. So Lopata was fired from his job. He went to his former employer and stole $5,000 worth of oil barrels, being the amount that he honestly believed he was owed from his employer.
Yes. And the most important part of this is one, doesn't matter his belief was correct or wasn't or
Or
whatever,
unreasonable.
was unreasonable, but as long as he genuinely and truly believed,
Yes.
that's what court gives a shit. Another one, he stole equal or lesser amount.
Mhm.
And they said because he attempted to steal equal or lesser amount, then he doesn't violate this part. But there are other cases the person steals a little bit more to be on the safe side, to make sure he gets this amount of money he wanted. And that's the problem. The judge will say no, less than or equal than what the person you believe they owe to you,
Yes.
that's fine. But anything more than that is larceny.
Correct. You cannot. It's not defensible.
Yes, it's not
You still-
defensible.
yeah.
That's the correct words. And Hungry Jack, if you explain, I'm going to get some water.
So with Hungry Jacks, the same thing. The employee, a former employee, was fired. He was a part of a group that went back to steal money to recover the amount of wages that he thought he was owed. Unfortunately, he went back with a weapon and committed a robbery. Took more than He
What
was
she?
owed?
Yeah,
He or she was owed?
yeah. I think it's a she. Yeah.
He?
Oh, it's a he.
Yes.
Mm.
And the other offenders did not take that seriously, so when he appealed, it was dismissed.
Yeah, exactly.
Okay.
So that's what to talk about the quantity. You shouldn't take more than what you should. If you have an honest belief, take either the equal amount
Yes.
or less. That's
Yes.
okay.
Yes.
But if you take more than that, then it's larceny. The rest is larceny.
Correct.
And then we have to come back to one of the mental element is permanently deprived. And the key case is
Foster. So where Mr. Foster was a guest at a
young
house,
man.
and he took a gun belonging to the owner of the house and went to show it off to various people, declaring that he did not own the gun, but he wanted to show his parents and others the gun.
And importantly, in this case, and that's why they said that he actually didn't permanently deprive, because he didn't claim that the gun belonged to him. All the time he claimed that the gun belonged to someone else.
Yes.
So he didn't claim the possession, the ownership of that property. And particularly, he didn't use it as well.
That's correct.
He didn't
did
appropriate
not fire it.
the property at all. And therefore, he didn't have the intention to permanently deprive the owner of the property.
Yeah.
Therefore, he didn't amount to larceny. And then, but we have another two cases, Mingle case and Cockburn. Now, Cockburn is one of the one that he committed to larceny, is convicted.
Right.
And that's the case where he took £50 from the cash register, and he said that, oh, well, I wanted to put the check.
Intending to return it the
Yeah.
next day.
But they say even though you have intention to return, at the time of taking, it's already larceny. It doesn't matter if you replace it later.
Because it doesn't mean that you did not have the intention when you took the money originally.
And they said you will return it in different currency. So I said, if you have, let's say, $50, return $50, I would have accepted, which I believe that's a lie. So just avoiding it to get this poor person into jail. And say, no, you're returning it another currency. That's why I believe beyond reasonable doubt you need to go to jail. So right or wrong, which I believe it was wrong, this judgment, and that's the authority for permanently deprivation.
And then now, then we can, move on.
Section 4B?
Yeah, because it says, dishonesty or fraudulence, including this honest belief of claim of right. So we have two cases talk about claim of right earlier. And then regarding dishonesty, there are other two cases that hasn't been mentioned so much in lectures, but it's good to know about it.
No, it has been mentioned. I remember they clearly said that
Which one
test 4B.
No, I
The
say,
definition of 4B.
well, definition of 4B, yes, but I'm saying the cases that is related.
Don't you remember they explained the lawyer case? That
The lawyer case?
Yes.
Was that Gosh?
they said,
Gosh.
the lawyer, he did, as you mentioned, tax return,
Oh,
tempered,
yes. Yep.
and then
Oh,
they discussed about the standard.
That was Peters.
Or the standard of
Yeah, Peters. So
ordinary
Mr. Peters was a
solicitor.
a solicitor who was charged with conspiracy to defraud the Commonwealth by submitting a deceptive tax return, and the test was that it was something that a reasonable or a general person would not have done, or would have known that it was dishonest, and importantly that he would have known that
Yes.
as well.
Yeah.
So collective 4B, as section 4B says, if collectively normal people
Yes.
would believe that's done whatever it was has been fraudulent.
Mhm.
That's the test.
Yes.
If collectively believe it's not fraudulent, it's okay. But if collectively believe, yes, a lawyer shouldn't do that, then that's considered fraudulent.
And particularly the defendant is already known that he's
Yes,
doing a
that's his
fraudulent.
job
That's
to
important
know.
that the
That's his
defendant already
fucking job to
knows-
know.
Yeah,
That already knows that it's dishonest.
yeah.
Yes.
Yes.
And that's why you got two cases, which is
Another one was,
Peters
yes,
and how do you say that?
McLeod.
McLeod.
not cloud,
Yeah.
put M in it.
I know, it's just when you read it, it doesn't look like cloud, is it? McLeod.
How did you pronounce it?
McLeod.
No, how did you originally pronounce it?
McLeod.
No, now she completely denies it.
So
Now we
he,
won't leave it all.
Okay.
so McLeod, he had various companies, and he has one of the biggest company he owned himself, and he had people invested in that company for around $11 million. But he spent a big portion, a few $1 million for his own benefit, like buying house or buying cars, buying luxuries. Therefore, well, do you think he was past the Section 4B honesty test? I don't think so.
And he claimed that
He claimed that he had a justified right to use that money because he hadn't drawn a salary in the early days and he felt that the company owed him that money.
maybe 1 million per an hour salary.
$1 million an hour.
Yeah.
Yeah.
So that was a funny justification.
Yeah.
So that's for first section. After that, we have a doctrine of continuous trespass.
And key
I-
cases.
Key cases, I need to say my nicknames first. But I remember those key cases. One is black sheep and one is the wallet case.
Mhm.
Facts would be black sheep.
Black sheep
Yes.
was Riley.
Yeah.
Riley. And Mr. Riley was a shepherd who was taking his sheep to market. He stopped overnight in a farmer's property. Some of the farmer's sheep got mixed up with his own flock. He took off in the morning. He didn't realise the extra sheep were there until he was a ways away. But when he discovered, he said, well, I'm just going to go and head anyway. So at that point,
Even better.
Even better. So this goes to the contemporaneous nature or the contemporaneity of the actus reus, the physical act of the taking, and the mens rea, the dishonest intention. Typically, they occur at the same time, that is, they are contemporaneous. However, in this case, the doctrine of continuing trespass against the farmer's ownership of the sheep was established, which said that you could in fact commit, the contemporaneity did not need to be there under this circumstance.
Yeah. So the mens rea come out.
So in a dumb
Yes.
language
That's
says
the simple
Yep.
explanation.
Mens rea come out.
so in a layman language it says the moment you realize the ship is not yours, you could just stop what you were doing, but you chose because it was a financial gratification to take it. No matter how you spend the money after that, you give it to charity, you burn it, you do whatever you want to do, you commit the larceny because you broke this doctrine of continuing trespass. You continued trespass wrongdoing, right?
Yes.
You continued doing wrongdoing that you knew it wasn't yours. So
Yes.
second one was
Wallet.
wallet case.
The wallet case with
Yes.
the
Mingle.
Mingle. Mr. Mingle found a wallet in the TAB and said that I found a wallet in the TAB, I didn't know who it belonged to, and I did not bother to check. He took it home, and a couple of days later, he opened the wallet, saw an ID card in there, and did not return it.
And decided to keep it. Therefore, the mens rea happened after.
Yes.
So in a plain language, it comes there to say, okay, till the time you chose not to know it, not to investigate it, it's fine. But since the moment you saw the photo ID on it, you realized it's not yours. So first you didn't attempt to find who the person is. And second, you just decided to take it yourself and treat it as if it's yours. So
Yes.
then you continue doing wrongdoing. That's doctrine of trespass. After that,
And that's why that case goes under larceny by finding as well.
yes, larceny
Yes.
by fine.
Because he found it, he didn't steal it, right? But he didn't take reasonable steps to find the owner, even though he knows who is the owner later on. He didn't do anything about it.
Yes.
Okay.
Yeah.
Then we have three more type of larceny. Larceny by mistake. The previous one was general larceny. Now is larceny, another one is by mistake, larceny by finding, larceny by trick. So total 4.
Mm.
So if we go to larceny by mistake, I remember with that famous case, a vet clinic case, which you call it with Illich.
Illich,
Mr.
yeah.
Illich?
Yes.
Yes.
We already discussed 3.
Oh, another thing to take from that is in Illich case, yes, it defined the elements of larceny, but it also defined what is called the fundamental mistake.
Oh, yes.
That's
the
very
fundamental
important.
mistakes.
And there are 3 of them.
3 of them. What do you?
The first mistake is the mistake in the identity of the transferee. That is, to whom you are giving the object to.
Receiver.
The receiver.
Yes.
Thank you. The first one. The second mistake is in the amount of the item that you're giving, where you may intend to give 10 of something and you give 20.
Yes.
So that's the mistake. And then it's the type of property. So you may think you're giving a person something X, and in fact you're giving them Y.
Wow.
So they're the 3 fundamental mistakes.
Yes, those are called fundamental mistake. And it's defined in Illich. And they use it in a case, it's called potisk.
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 3 cases we referred to. One was the currency exchange.
That's the potisk.
Yes. Another one was bank that gave a bank cashier gave the wrong amount. Another one was they transferred the huge amount of money mistakenly to the person's account.
Yes.
So let's we discuss 3 and in a bit more detail, and we get any.
So I can talk about the large amount. It was a young fellow in Goulburn in central New South Wales.
And what is it called? Shields?
Shields.
Yes.
Mr. Shields.
Shields.
Mr. Shields. So Mr. Shields was the fortunate recipient of a large amount of money wrongly transferred into his account. He believed, well, he had no reason to believe that it wasn't his,
Yep.
apparently. So he went and spent it all.
Yeah.
And then he was convicted of larceny by mistake
But in fact, the mistake was.
on the part of the bank.
But
However,
yes.
yes, no, go on.
Yeah, you
Oh, all right. So, however, the judge said you knew it wasn't yours. You knew that you were not entitled to it.
And you continue.
You took no reasonable steps to notify the bank,
It's 8 o'clock.
and you continued to take advantage of the situation.
Fuck you. So that's exactly what that happened.
Yes.
They said no money wasn't yours.
Yes, and you knew it.
Yes. And he I remember that he bought a Bentley with it.
Yeah, he bought. Yeah.
Many expensive cars, house,
Yeah.
whatever. Just keep buying, spending.
Instead of taking to another country, park it there, and use how dumb and stupid you should flag yourself.
And unfortunately for him, the police academy is in Goulburn.
Oh no. So another one was currency exchange.
Traveler's check.
This
It's-
was where the teller gave the wrong amount.
Yeah. She mistakenly with the exchange rate,
Yes.
and therefore she gave more money to what's his name?
Mr. Potisk.
Potisk.
Mm-hmm.
But it's the same. Like he realized that actually he received more money than he should. He actually realized that. But yes, he didn't take any reasonable steps and says, "Oh, you actually give me more money," and he just decided to keep it and use it. So
Yes.
that still amount to larceny.
Yes.
It was dishonest, isn't it?
Yes.
And another one was the bank teller gives more money, and the person takes the money, and but court tells that He had no association with the teller, so it's not something fabricated.
Yes.
And it's just an honest mistake from the teller's side, and he didn't know it. He really, and that's not a problem much. That's all as much as I remember. But it can be wrong.
Yeah.
And it's cited Illich as well and say that what are the fundamental mistakes? And so they use the fundamental mistake test to test whether the mistake is fundamental.
So all you need to know, just to know the Illich and or vet clinic nickname I gave, and they use it to say these three, and that's how you can cover everything they're given to you by mistake.
Yes.
Second last one is larceny by finding, which is I have a nickname camera, gold coin, and tab case. Tab case you already discussed. Camera and gold coin is going to be discussed. Which
so I'll talk about the camera. I call it the camera on the fence case,
yes.
where a fellow was walking past a house, saw a camera hanging by the strap on the fence, picked it up and talked to a neighbour and said, "Do you own this camera?" And the neighbour replied, "No." So the fellow then said, "Oh, obviously no one owns it. I'll take it for myself. It's been abandoned." That was the justification he used to himself. But again, I think the real owner reported it. He was found with the camera. And again, the judge said, you took no reasonable steps to find the true owner. You could have actually returned it to the police station. You could have asked around, but you did not, so you're done.
Yeah, in our language we have as a fox ask his tail a question. Do you think this belongs to anyone? And tail says no. So, well, I took a reasonable step to do whatever I needed to do to find the owner. Then my tail says no, there is no owner. Then I have the honest belief of right. That's that's mine.
Right.
Yes.
Then the last case is Thurbon.
Gold coin.
Yeah, gold coin.
Oh, that was Mr. Thurbon.
Thurbon.
Oh, okay.
So very, very old English case, and he found a bag of gold coin on the street, and he says, "Oh, there's no name tag there. There is no anything to tell me it belongs to someone. There is no one." Then he honestly believes it's abandoned. Then okay, he took it. But I think it's quite stupid. He stupidly went to a pub and says, "Oh, I found a bag of gold coin. I want to shout everyone a drink." And luckily, the owner of the and unluckily for him, and the owner of the bag of gold coin was there. He said, "Hey, it's mine. It belonged to me. You stole that bag of gold coin from me."
And the last one is larceny by trick, which two leading cases. One is I remember with nickname of 7 days, and another one is nickname of horse, which you will place short and effective facts and any ratio decision to take from there.
So I'll talk about the horse.
You can lie anywhere.
Yeah, you please
So
continue.
Mr. Pear,
Yeah, Pear.
rented a horse from a fellow for the day, but then went on to sell the horse and represented the horse as belonging to him, when in fact it was merely rented from someone else. When he was challenged, he said that he had the right to sell the horse because he had possession of the horse. And I think this case was important because it was the first time that it distinguished between ownership as opposed to mere possession.
Yes.
So he had no right of ownership in the horse, even though he had possession of the horse.
That's the most important part of this case.
Yeah.
Yes.
And that's why.
No, you will continue. I just highlighted. Please continue.
Yeah.
Oh, okay.
And that leads to another case, which is that.
The encyclopedia case.
Yes, exactly.
Where a well-known encyclopedia company would unsolicited send out, in the old days, a big box of encyclopedia, saying that you had a 7-day free trial, and if you didn't like it, you could return it at the end of that time. And the fellow that received the encyclopedia said, "I'm not going to return them because I have ownership of these, so I'm not going to return them." And the encyclopedia company charged him, had him charged with larceny. The judge said that to the encyclopedia company, you've essentially forced yourself on this person, and he has no obligation to return the encyclopedia to you.
So it's again the distinction between the possession and the ownership.
Yes.
Yes.
And his obligation to return, because he had possession.
Yes.
Whether he had ownership or not, I'm not sure.
No, he
to be
didn't
honest.
sell it to make money from it whatsoever.
It was forcing that person to have ownership so they can.
No,
Get
he
it.
didn't take like a horse case to say, now it's mine, I'm gonna sell it. He just said, fuck you, I'm not gonna return you because I have no legal duty to return you because I haven't asked you to send me at the first place.
Yes.
I don't have an agreement, I don't have a contract, I don't have any association. I just open my door, Dada, or my mailbox, this isn't yours, take it. After 7 days you must return it. What about if it costs me to return it?
Yes,
What about I
indeed.
need to hire someone to return it? What about if people are disabled, they can't return it?
Yes.
You can't just go around and say, oh, I'm gonna charge you with larceny, you must return it because I sent it to you.
Yes.
So that was the authority that judge said, say, oh no, please fuck off. That's not gonna happen. And that was all about larceny we need to know, I believe.
Yes.
And then tomorrow we'll continue with fraud and other offense under larceny.
Thanks, Trev. Thanks,
Yes,
everyone.
great to have
Thanks,
Trev
guys.
here.
Thanks.
And Marco's lying down there.